46, the 1346, that's called the head of the agency. They said liability, because if you don't have a liability, you cannot be. It's the IRS, Department of Labor, that's governed by the Federal Tort Claim Act of 1346 and this 2670 XE, or the applicable statutory the 1346 of the United States as the defendants. Okay, that's what the law is. The law is the head of the agency to enforce liability. But if you don't have no liability, you can't really enforce it. So the head of that agency plus the head of that agency, that's governed under the Attorney General's office. And that's what they call by they sign the power of attorney under the 2848. If you go here under the 2848, the power of attorney give to the Attorney General's office. That's the Attorney General's office now represent the United States, because the IRS and the Department of Labor itself, it's only the taxpayer can really open the tax return. So it's to change the mechanics of the 1099 and then to change it to the Social Security benefits by making it a W-2 form. But they're not gonna pay federal taxes, they're only gonna pay Social Security benefits. And that's what the 6103 is all about. And you need to really understand the Department of Labor, the IRS, and the power of attorney. That's basically what make it the United States. The United States versus the corporate officer. And then that's the motion under the 6103 by the Attorney General. That's what it become the United States versus John Doe. John Doe is the corporate officer that really register the corporations. That's the benefits, not provide Social Security benefits to his employee under 1099. That's what they're gonna now have the employer pay 6.2% under Social Security and 1.45 under Medicare, and now the employer gonna pay both. If he was withheld prior, then the employee will pay half and the employer will pay half. Since the violations is to already take place, and that's what the liquidated damage is. The liquidated damage is the portion of the employer plus the portion of the employee because the employer failed to make it on time. And that's what it become against the corporate officer to in front of the grand jury, and that was the crime that's committed for 6 months in jail and pay restitutions. And that goes against the corporate officer because the corporate officers take the profit into their Social Security and the 1040. And he transfer from the 1120S to go through his 1040. And that's what the Attorney General now gonna go on the record by saying, on this day of January 23, come to the attention of the court the application the United States Attorney General's office. If it's in New York, gonna be Eastern New York. Well, this one was in Western Pennsylvania. The party basically pursues to the 2161 I-1 drafted that the Internal Revenue Services to disclose their tax return. So each one have to sign a consent, and that's why they under the Department of Labor they sign the consent. And the consent means that they have to open the tax return. Mr. X, it's live in 111-11 Pittsburgh, Pennsylvania, and their Social Security it's 111-111-111. So now if you have 300 people, you have 300 Social Security. Each one has to really have this done in front of the grand jury. And the grand jury now will have a summary in every victim and the case. And now, you see, there is a reasonable, the court for taxable period from January 1st to December 31st, after examining the application to the court and finding that there is reasonable to believe that based on the informations that the violations of the federal criminal statute was similarly done. As above, the possession of the Internal Revenue Services subsequently to the date of this order, but far not longer than 90 days. Disclose such return and return informations, make the certification of the application to special agent and Mr. Y and no other person to disclose no return, and the return information not to describe above. It is further ordered the application of the officer of an employee of the federal assigned this matter shall have a return information solely in investigating an above mentioned violation of the 6103 sections, such other violations of any criminal statute, although presently unknown, as discovered in the course of the investigation of the ex parte motion for preparing the matter for trial. No disclosure be made for any person except in accordance with the provision of the 2661 and the 26 CFR 301 and the 6103 I1 and the United States District Judge. And then the date is 01/30/2023, and verification of Mr. White first deal and depose that I am the Assistant Attorney General to the Western District of Pennsylvania. That application is made the basic of informations officially further up to the basis of such information to be true and verified. 26 U.S.C. Section 6103 I1, the 26 6103 Section I2, the 26 U.S.C. Sections 6103 I3, 6103 I4 have been committed. There is reasonable cause to believe that the return and the return informations are relevant to this matter and relating to this commission. Such act, the return and the return information are served exclusively for the federal criminal procedure concerning such act. The information is served to be disclosed cannot reasonably obtained under the subconsent from another sources. The court further find applicant is an employee of the United States, officer of the Western District of Pennsylvania, is primarily directly engaged in informations served is solely for their and used in investigations of the above violation under 2661 section. And the application is authorized the United States for the Western District of Pennsylvania. Is therefore agreed that the Internal Revenue Services disclose the return for Mr. X, Mr. Y, 111-11, 111 Pittsburgh, Pennsylvania, and the Social Security is 111-111-111. For the tax period filed within the Internal Revenue Services to certify where the return and return information described have not been filed and not been filed with the Internal Revenue Services, that no such return and return information has been filed or on file for 3 disclosure. That's 3 years. And believe the Assistant Attorney General swear and depose and notarize it by the commissioner. In other words, you have to be notarized, this paper. And then this paper here will go in front of the grand jury and have all the victim that signed this order. And that's where each tax return will have to really change the taxable income for the last 3 years. And then that's what the restitution is for 6 months in jail. And the restitution for, if there are 300 people, they will have 300 affidavit, 300 consent, 300 people that are victim on the hand of the corporate officer that was misclassified, the employee, and then that was sent at a 1099 instead of the W-2 form. And that's when the grand jury now the judge gonna send the corporate officer to 6 months in jail, and then have the restitution paid and sent to the Department of Labor, and the IRS now will take the money and send it to the Treasury Department. And the case is over. And that's the enforcement mechanics by the two federal branch that become the United States against the corporate officer. And thank you for listening.